Hello, my name is Diego Ramirez. This is the Critical Assignment Legal Issues in Kinesiology with Dr. Donna Clemens, Kinesiology 550. Let's get started. This presentation's overview will focus on facility background, risk management, employment laws, application, and faith integration. The facility we'll be looking at is a fitness center where fitness for personal training happens, group exercise training happens, open functional gym where cardio training equipment is available, treadmills, ellipticals, stationary bike, etc. Limited secularized strength training equipment, mainly because we're going on the open functional gym. That's the trend that the fitness industry is going, more functional, more open space that allows for free weights, barbells, dumbbells, kettlebells. Wet area as well, pool, sauna, steam room, showers, and of course locker rooms for clients, and playing courts such as basketball courts or volleyball courts. The reason I chose this was because since 2005, when I started in the fitness industry, I've always envisioned something to provide personal trainers with open space that they can rent and they can come and bring their clientele to train, and also provide myself employment for other trainers that don't have clientele yet, so they can get their business started and run off the bat, and obviously also provide a fitness facility for clients that want to get started in the fitness. Past legal issues in kinesiology here that we can look at, or for this specific facility, Link versus Fitness 19. This client, Mr. Link, actually suffered rhabdomyolysis and is blaming the personal training caused rhabdomyolysis on him. And the court filed a summary judgment based on exculpatory clause in agreement. Plaintiff and because the plaintiff also failed to establish proximate cause. This is helpful because when management or owners are hiring and training for safer programs, they can actually take a look at something like, hey, focus on what you're doing. Make sure that you're taking care of your clientele. Make sure you're taking care of make sure you're taking care of the people that you're in charge of. And obviously, development of injury reports, if there's none available, this can definitely help us. Second issue, Buparthu versus 24-Hour Fitness. This was Mr. Buparthu it claims that 24-Hour Fitness violated the Fair Labor Standards Act, FLSA, for fail to compensate overtime. I myself was a trainer for a few years where you go over your time and during your client's session, and sometimes 1 minute to 10 minutes, and if you're doing 30, 40, 50 hours, that can add up for sure, and not being able to report that can have some huge impact. So for management, development of and a plan and minimizing labor costs and overtimes without obviously violating laws would be helpful. The third issue that we can see here is Jones versus LA Fitness International. Mr. Jones suffered an injury while playing basketball. There was no posted signs of hazardous and dangerous conditions of the basketball courts, and he ran into a wall where there's no padding, so he wasn't able to absorb that impact, and his body suffered an injury. So employees, managers, and owners must be diligent on monitoring and assessing risk associated with the use of equipment and facilities. Risk management. The first issue we can see here, this case of Lafada versus LA Fitness International. Mr. Lafada was injured while using a Cybex bench. He sued LA Fitness for negligence and willful injury. The court granted summary judgment in favor of LA Fitness, citing action barred by release of liability clause included in membership agreement. So for management, every new member or guest must sign a release of liability agreement. This is very important whether you have a guest or a potential new client, that they must sign this. Report any equipment from malfunction. So there should be an equipment log available. And when there is broken equipment or malfunctioning, have a trained professional repair broken equipment, whether you have somebody in-house or whether you contract somebody else that will be that's already prepared and is a professional to be able to take care of this. The entire team must be trained on the procedures to follow so that everyone's taken care of and avoid further damage in the event that something like this does happen. So immediate medical care, documentation such as incident reports, and public relations. So let's say something catastrophic does happen, we want to make sure, if media gets a hold of this, then how do we go about it and how do we proceed? Another case that we could look at is Toro versus Fitness International. Mr. Toro suffered injuries due to a fall in the showers, and he sued Fitness International for negligence. The court granted summary judgment in favor of Fitness International, citing again the clause of release of liability in the membership agreement. So for management is also again identify what the potential risk in the locker room are. So falls, cleanliness, excess water not draining, etc. It's unlawful to have cameras in the locker room, so you want to make sure that you have somebody that's constantly going in there, making sure that everything is up and running. Make sure there's no risk. Hire janitorial staff, or again contract somebody if you don't have an in-house person, and maintenance cleaning log. So we can see here there's a log right back there, and also lets your clients know that hey, this is getting taken care of, but also it keeps your staff accountable. Constantly train existing and new staff on proper procedures to ensure flawless execution, and this should be revisited often for improvement and adjustments. Last case we'll look at here, La Quirica versus Metropolitan YMCA of the Oranges. Miss La Quirica, fractured her wrist, lacerated her scalp, and suffered a concussion when she fell while participating in a group fitness class. She sued for negligence and injuries suffered as part of the fall. And in the disposition, the class instructor stated no formal training was ever given by Metro YMCA. So yes, they were required to attend meetings where the main points were to grow business and how to make classes more attractive, but never was there any training, how to actually go about attending to an injury. So management can review with the assistance of their group training staff, identify potential risk in the exercise rooms, review protocols on how to fill out incident reports, collect pertinent certifications such as CPR or group teaching certifications to make sure that everybody's up to date with their training. Employment laws. So Pimple versus Fitness International, sexual harassment case where Miss Pimple reported sexual harassment to the operation manager, who was aware of other such reports, but she failed to act. And Fitness International filed a motion to compel arbitration due to initial employment agreement signed by the plaintiff. And the court found that the arbitration agreement was unconscionable. So Ms. Pimple brought up a case. So for management, provide a safe and comfortable working environment. This, will increase your productivity, increase sales, increase the happiness around your staff, and also for your clientele. Hold everybody accountable, regardless of where they're at in terms of the chain of command. Everybody needs to be held accountable, and report any unlawful actions to appropriate agencies. Another case, Prusner versus Oz Fitness. Ms. Prusner went on maternity leave, and when she came back, was not reinstated to her position. She was replaced by a male manager, so she claims that she was discriminated against, and that Oz Fitness violated the Family and Medical Leave Act. So for management, professional advice when in doubt about any particular issue regarding FMLA. So this could be a lawyer that you can have as an advisor when it comes to this. And employers can pursue workshops or training programs where such issues are presented and how to better handle them. So Department of Labor has a bunch of tools that one can go in and look at. So this one here, Employers Guide to the Family and Medical Leave Act. And another is Ascari versus LA Fitness International. Mr. Ascari claims that he was discriminated against on the basis of race, and that his termination was because of race, and he was exposed to a hostile work environment, which violates the Civil Rights Act of 1964. LA Fitness reasons was actually Mr. Ascari was terminated because of multiple instances where he was insubordinate towards management and failed to follow orders. Summary judgment was awarded in favor of LA Fitness. So this can show us that proper documentation such as disciplinary action forms need to be in place, and plan of action on the steps and procedures that must be followed when undesired conduct or low performance in a job occur. How can I apply this? Tort law, negligence. I learned a lot in the last 7 weeks, of course, but negligence is something that obviously now pops more into my head as I walk through the fitness center where I work at, and the potential if I ever open my own business or go to another facility. Risk management was actually obviously loss prevention, maintaining, providing proper equipment, but the approach was the one that spoke to me the most, because you have to go in there with open eyes. You have to go in there with an open mentality. Obviously, like they say, hope for the best, but expect the worst. That's how I plan to apply it. Employment law, discrimination. I was subject to discrimination because I'm a minority male, and I suffered, so I know what not to do, and because I don't want other people to feel what I felt. Obviously sexual harassment as well, is very prevalent, unfortunately still among men and women, and obviously be up to date with the federal employment laws. Constitutional law, the First Amendment, of course, and the Fifth Amendment, but the one that spoke to me the most was actually the 14th Amendment, which we're all the same. We all should be protected under the laws, and if you need any specific there's any legal issue, I should say, we're all the same, regardless of where you come from, who you are. Faith integration, Proverbs 11:14, where there's no guidance, a people falls, but in the abundance of counselors, there's safety. So for this one, as a manager or as an owner, you can't do everything on your own. That's why you should have, or when you have counselors such as lawyers, HR department, when you have a cleaning crew, a maintenance crew, a front desk, personal trainers, a group training class instructors, that is where there's that safety. Okay, that safety net that can actually help you run your business. Corinthians 14:40, but all things should be done decently and in order. That's regardless if you're hiring somebody or do you discipline somebody, and that's how you do it. That's where this can be actually applied. It should be done decently and in order. Ecclesiastes 3:16 through 17. Moreover, I saw under the sun that in the place of justice even there was wickedness, and in the place of righteousness even there was wickedness. I said in my heart, God will judge the righteous and the wicked, for there is time for every matter and for every work. So the law might not be perfect, okay, but at the end of the road, we're all going to be judged by God. And if we do everything right, there's nothing to fear. Lastly, somebody can get in trouble running because they follow God's word. Speak up for those who cannot speak for themselves, for the rights of all who are destitute. Proverbs 31:8. So this one, unfortunately, most people that feel like they don't have the rights, are minorities, and those are the people that are doing the cleaning, the maintenance. And so this is where somebody like a manager can get into trouble for obviously speaking up on their behalf. Here are my references. I thank you for viewing my presentation. You have a wonderful night. Thank you.